Case number 1. Ryan Widmer. The house on Crestview Drive was quiet by 10 o'clock on the night of August 11th, 2008. Ryan Widmer, 27 years old, called 911 to report that he had gone upstairs and found his wife face down in the bathtub. He had pulled her out. She was not responding. Officers from the Warren County Sheriff's Office arrived within 6 minutes of that call. They moved through the front door and up to the master bathroom. The bathtub was dry. Ryan Timothy Widmer had graduated from Miami University in Ohio and built a career in sports marketing and corporate event planning. He was well regarded in the Hamilton Township community, described by neighbors and acquaintances as a normal, happy newlywed. He had no prior criminal record, no documented history of violence, and no financial pressure investigators could plainly establish as a motive. He and Sarah had married in April 2008, 4 months before her death. Their household was stable, two-income, ordinary by every external measure. The prosecution would struggle across 3 separate trials to articulate a compelling reason for what they alleged he had done. What they had instead were specific physical facts that contradicted the account Ryan gave, and that, taken together, told investigators a different story than the one he offered. Sarah Widmer was 24 years old. She worked as a dental hygienist and was by every account from patients, colleagues, and family genuinely beloved. The kind of professional whose presence made an appointment less anxious and whose absence, after her death, left a gap that her patients and coworkers found hard to describe without emotion. She was close to her mother and her brother. She had a documented heart murmur, a minor condition, rarely symptomatic, noted in her medical history, that would become the centerpiece of her husband's defense across 3 trials. On the evening of August 11th, she had gone upstairs to take a bath while Ryan stayed on the main floor watching television. She did not come back down. Ryan's account to investigators was consistent from the beginning. He had been watching football downstairs, had gone upstairs to check on Sarah after some time had passed, and found her face down and unresponsive in the bathtub. He pulled her out, placed her on the bathroom floor, and called 911 immediately. Paramedics and officers arrived within 6 minutes of that call to find Sarah on the floor. She was transported to a hospital where she was pronounced dead. The autopsy that followed identified bruising on her scalp, bruising around her neck, and blunt force injury to the external tissue surrounding her heart. Findings that the medical examiner concluded were not consistent with an unwitnessed accidental drowning. The dry bathtub was the first contradiction. The distribution of Sarah's injuries was the second. Her hair, when officers arrived, was damp but not saturated. The condition of hair that has been briefly submerged, not of someone who has been lying undetected in water long enough to lose consciousness and drown without a struggle. Ryan Widmer was arrested 2 days after Sarah's death, on August 13th, 2008, and charged with aggravated murder and murder. The investigation was led by Lieutenant Jeff Braley of the Warren County Sheriff's Office, whose scene observations and analysis of the physical evidence were central to the prosecution's theory of the case. The defense, under attorney Charlie Ritgers, argued throughout that Sarah had suffered a sudden, undiagnosed medical event, a vasovagal episode or acute cardiac arrhythmia, consistent with her documented heart condition, that caused her to lose consciousness and drown before Ryan could reach her. The medical vulnerability was real and documented. Whether it explained the dry tub and the injury pattern was the question that juries in Warren County spent years trying to answer. What followed was procedurally extraordinary. Ryan Widmer was tried in 2009. The jury could not reach a verdict. He was tried again in 2010. The jury again could not reach a verdict. On February 15, 2011, following his third trial before a Warren County jury, he was found guilty of murder. The prosecution had focused substantially on the physical evidence: the dry tub, the injury distribution inconsistent with drowning, and on the analysis of the 911 call itself, which prosecutors argued reflected a tone and a set of linguistic choices inconsistent with a man who had just discovered his wife dying in their bathroom. The defense maintained, across all three proceedings, that the state had built its case around the absence of water and a set of injuries that a sudden cardiac event could have produced before or during a drowning. Ryan Widmer was sentenced to 15 years to life and is currently held at Marion Correctional Institution in Ohio. His post-conviction appeals have been handled in part by attorney Mark Godsey of the Ohio Innocence Project. His earliest parole eligibility arrived in July 2025. Whether a parole hearing occurred and what its outcome was had not been confirmed in public records at the time of this writing. A detail in this case has never been fully resolved by the courts. Lieutenant Jeff Braley, the lead investigator whose scene observations anchored the prosecution's physical theory, was later exposed as having fabricated credentials on his professional resume. He had claimed a master's degree he did not hold. He had claimed a Special Forces military background he did not have. The investigation that produced 3 trials and a murder conviction was led by a detective who had lied about who he was. Whether those observations and conclusions would have carried the same weight under the scrutiny they deserved remains an open question. Sarah Widmer was 24 years old. She had been married for 4 months. Case number 2. Dr. Robert Newlander. He came back from his morning run the way he did on most mornings, through the door of the house on Windward Path in the town of DeWitt, outside Syracuse, New York. What he found, Robert Newlander would tell investigators, was his wife Leslie bleeding on the floor of the upper bathroom's shower stall. He moved her to the bedroom. He called for his adult daughter, Jenna, to come from her room and call 911. Officers arrived to find Leslie Newlander with severe head injuries. She died. The question that would take nearly a decade and 2 separate murder trials to adjudicate was not what killed her, but where, and where the blood was told. Investigators a story that differed fundamentally from the one Robert Newlander had offered. Robert Mitchell Newlander was 60 years old and one of the most successful OB/GYN physicians in the greater Syracuse region. He had spent more than 3 decades building a medical practice and a professional reputation that placed him among the prominent figures of his community. He was financially comfortable by any standard, a multimillionaire with the assets and lifestyle to match. He had 4 adult children, a long-standing position in the medical community, and a marriage that, according to sources close to the family, had been quietly deteriorating for some time. By the fall of 2012, the Newlanders were reportedly in the process of a separation. For Robert Newlander, the financial cost of that separation, what a divorce from Leslie, with her decades of marital standing would require, was substantial. That cost was the motive prosecutors would present to the jury. Leslie Newlander was 61 years old. She had spent much of her adult life engaged in philanthropic work in the Syracuse area, and she was regarded in those circles as a warm, generous, and genuinely committed presence. She suffered from vertigo, a condition her husband, a physician, was medically equipped to understand in detail, and one the defense would point to as a possible explanation for an accidental fall. On the morning of September 17th, 2012, at 8314 Windward Path in the town of DeWitt. She died from blunt force trauma to the head. She was found not in the shower where Robert said he had found her, but in the bedroom. Newlander's account was specific. He returned from his morning run, found Leslie bleeding in the shower, moved her to the bedroom as he tried to help her, and called for his daughter. Jenna's 911 call, placed with Robert audible and agitated in the background, was the first piece of evidence reviewed. It would not be the most significant. Forensic examination of the bedroom found extensive blood spatter on the headboard and the wall above the bed, a pattern that was irreconcilable with a woman who had been struck in the shower and moved. Blood spatter analysis indicated that Leslie Newlander had been beaten in the bedroom. The blood on the headboard did not travel there from the shower. The blood was where the assault had occurred. The investigation spanned 21 months before Robert Newlander was arrested in June 2014 and charged with murder. His first trial in Onondaga County, held in April 2015, placed the blood spatter evidence at the center of the prosecution's case, alongside the physical contradiction between Newlander's account and the location of the blood. Prosecutors also addressed the 911 call directly, instructing the jury to listen to Robert Newlander's voice in the background of Jenna's call and to ask whether what they heard was a man reacting to the discovery of his dying wife, or a man performing that reaction for whoever was recording it. Explicitly, the jury was told they were listening to a bad actor giving a bad performance. They found Newlander guilty of murder. That conviction was overturned on appeal. The grounds were not specified in public records available for this account. Newlander was retried, and in March 2022, nearly a decade after Leslie's death and 10 years after the morning run he described, a second jury in Onondaga County found him guilty of murder again. The blood on the bedroom headboard, and the account that could not be made consistent with where that blood was, had survived 2 separate trial proceedings and convinced 2 separate juries. Robert Newlander was sentenced to 20 years to life. He is currently incarcerated at Elmira Correctional Facility in New York. He is 72 years old. His earliest eligibility for parole is 2042, by which point he will be in his late 80s. She was 61 years old. She had suffered from vertigo. She had a husband who was a physician, and she was found not in the shower where he said she had fallen, but in the bedroom, with the blood on the wall above the bed, contradicting the account that was told to the dispatcher. The 21-month gap between Leslie's death and Robert Newlander's arrest in June 2014 was itself unusual for a domestic homicide and reflected the complexity of building a forensic case against a wealthy, prominent physician with access to skilled legal representation. Investigators spent that period reconstructing the blood spatter evidence, consulting with forensic experts, and building the factual foundation that would need to withstand cross-examination from defense counsel, experienced in challenging forensic science. The thoroughness of that preparation paid dividends across 2 separate trials. At the first trial, the defense argued that Leslie's vertigo could explain a fall severe enough to cause the head injuries documented in the autopsy, that a woman with a balance disorder might have fallen in the shower with enough force to produce the lacerations found. The prosecution's response was the bedroom wall. Leslie Newlander's injuries could be explained by a fall. The blood spatter on the bedroom headboard could not. Case number 3, Russell Faria. When investigators arrived at 130 Sumac Drive in Troy, Missouri, on the night of December 27, 2011, they found Elizabeth Faria dead on the living room floor, stabbed 55 times. Her husband Russell had called 911 in a state of panic after coming home from a game night at a friend's house. He had multiple witnesses who could confirm exactly where he had been. And 4 days before her death, Betsy Faria had changed the beneficiary of her $150,000 life insurance policy to a woman named Pamela Hupp, who had presented herself as one of Betsy's closest friends. Investigators did not spend significant time examining Pam Hupp. They focused on Russell Faria instead. Russell Faria was 41 years old and worked at an auto shop in the Troy area. He had no criminal record and no history of violence. He had been married to Betsy for years, and on the night she was killed, had been at a friend's home for a game night gathering that multiple people attended and could verify. When he came home and found his wife, he called 911 immediately. His conversation with the dispatcher was frantic and disoriented. In the shock of the moment, looking at the scene in front of him, he said he thought Betsy might have hurt herself. She had been diagnosed with terminal breast cancer and had been dealing with that diagnosis in the months before her death. His mind, reaching for an explanation in the first seconds, grasped at the most devastating context available. Prosecutors would take that statement and build a theory of guilt around it. They would also call in analysts to evaluate the 911 call itself. Elizabeth Faria, known to everyone as Betsy, was 42 years old. She had worked for State Farm and had spent the period since her cancer diagnosis managing her illness with the support of family and friends, including Pamela Hupp, who had become her most prominent companion in that difficult stretch. Betsy had signed a document naming Hupp as her life insurance beneficiary 4 days before her death. Hupp had driven Betsy home from a cancer treatment appointment on the same evening Betsy was killed. Those facts were available. They were not the facts investigators pursued. The 911 call analysis that prosecutors brought into the case rested on a premise that has since been extensively challenged in courts across the country: that trained listeners can reliably distinguish, from an audio recording alone, between genuine emotional distress and a performed version of the same. The analysts hired by the prosecution reviewed Russell Faria's crying on the call and concluded it was not authentic. There is no peer-reviewed science supporting that methodology at the reliability level required for courtroom evidence. In 2013, that analysis was enough to matter. Russell Faria was tried in November 2013 and convicted of first-degree murder. He was sent to prison for a crime that the evidence, examined properly, could not sustain. His conviction was overturned on appeal. At his retrial in 2015, with the Pam Hupp lead now being taken seriously, a jury found him not guilty. The investigation that followed focused on Hupp's movements, her finances, her relationship to Betsy, and the insurance money that had been paid to her after Betsy's death. In 2021, Pamela Hupp entered an Alford plea to the murder of Betsy Faria, acknowledging that sufficient evidence existed to support a conviction while formally maintaining her innocence. She was sentenced to life in prison without the possibility of parole. She is currently incarcerated at the Chillicothe Correctional Center in Missouri, where she is also serving a separate life sentence for the 2016 murder of Louis Gumpenberger, which is documented in the case that follows. The Faria case became, in the years after Russell's exoneration, one of the most frequently cited examples in the national conversation about 911 call analysis as courtroom evidence. Legal challenges to the technique multiplied. The argument that a grieving person's emotional response can be reliably assessed as authentic or performed through audio analysis alone, and that assessment used to secure a murder conviction, was exposed in this case with unusual clarity. The man whose grief was judged fake by listening to a recording was innocent. The real killer had changed the insurance beneficiary 4 days before committing the crime. Betsy Faria was 42 years old. She was fighting cancer. She had, in her final weeks, been systematically targeted by someone she trusted. The institutional consequences of the Faria wrongful conviction extended beyond the case itself. In the years following Russell's exoneration, defense attorneys in Missouri and other jurisdictions began citing the case directly when challenging the admission of 911 call analysis in criminal proceedings. Courts reviewing the technique applied increasing scrutiny to the qualifications of analysts and the scientific basis for their conclusions. Several jurisdictions moved to restrict or prohibit the admission of such testimony, citing the lack of peer-reviewed validation for the methodology. The prosecutors and investigators who had focused the Betsy Faria investigation on her grieving husband rather than on the woman who had just changed Betsy's insurance policy faced professional and public scrutiny, though formal accountability for the wrongful conviction was limited. Russell Faria was eventually released. The years he spent in prison for a murder committed by someone he knew, someone who had stood near the evidence of that murder from the beginning, were not returned to him. Russell Faria is free. He was acquitted in 2015 and has spent the years since his exoneration as one of the most visible faces of the national wrongful conviction reform movement. Betsy Faria was 42 years old. She was fighting for her life against cancer. She deserved an investigation that asked the right question first. Case number 4. Pam Hupp. On the afternoon of August 16, 2016, Pamela Marie Hupp called 911 from her home in O'Fallon, Missouri. There was an intruder, she told the dispatcher. A man had forced his way in. She was in danger. While she was speaking, she shot Louis Gumpenberger dead on the floor of her living room. She remained on the line afterwards, continuing to narrate. The 911 call she placed that afternoon was not an emergency call. It was the script of a crime she had already planned, recorded in real time as she carried it out. She had called 911 before killing him because the 911 call was part of the murder. Pamela Marie Hupp was 57 years old. She had spent her career as a life insurance administrator for State Farm, and she had spent the years before August 2016 consolidating a position that was, by that point, attracting serious investigative attention. In December 2011, she had been present at or near the home of a dying woman named Betsy Faria. On the night Betsy was stabbed 55 times. She had, 4 days before Betsy's death, arranged to become the sole beneficiary of Betsy's $150,000 life insurance policy. Betsy's husband, Russell, had been convicted of the murder in 2013 and subsequently exonerated and acquitted at retrial in 2015. The insurance money had already been paid to Hupp. By the summer of 2016, investigators working the Faria case were looking at Pamela Hupp with a degree of focus she had not experienced before. Her response was to engineer a second murder designed to send the scrutiny back toward Russell Faria. Louis Gumpenberger was 33 years old. He had been unemployed for several years due to severe physical and cognitive disabilities resulting from a prior traumatic brain injury. He had no connection to Russell Faria. He had never, in his life, had any contact with Pamela Hupp before she approached him in a parking lot, told him she needed help with a film project, and offered him money to come with her. His disability made him easier to manage and less capable of effective resistance. She drove him to her home. She had prepared the props beforehand. She called 911 and began the performance she had rehearsed. Found in Gumpenberger's pocket after he was shot was a handwritten note purporting to document a plot by Russ Faria, claiming in its handwriting that Faria had paid Gumpenberger to come to Hupp's home and kill her to prevent her from testifying. The note was written on matched stock found in Hupp's home. The $900 in cash discovered in his pocket corresponded exactly, bill for sequential bill, to a withdrawal from Hupp's own bank account made days before the killing. She had written the note herself on her own paper and funded the props from her own account. She had then selected a man whose disability made him an easier target and brought him to a place from which he could not leave. Investigators who reviewed the 911 call noted the nature of what they heard. Her voice was composed. Her narration was organized. She described the intruder, his movements, and her own actions with a specificity that did not sound like the response of someone processing a genuine emergency in real time. It sounded, in the assessment investigators formed quickly, like someone reading from a mental script they had prepared in advance. The physical evidence confirmed what the audio suggested. She was arrested on the day of the killing and charged with murder. The death penalty was under consideration. Hupp entered an Alford plea to the Gumpenberger murder to avoid it, and was sentenced to life in prison without the possibility of parole. In 2021, she entered a second Alford plea, this one to the murder of Betsy Faria, and received a second life sentence to run alongside the first. She is currently incarcerated at the Chillicothe Correctional Center in Missouri. She is 65 years old. The note was written on her paper. The cash came from her account. The man she killed had never encountered Russell Faria. She committed her second documented murder while connected to 911 dispatch, and the recording of that call became evidence of premeditation rather than victimization. The staging was meticulous. The execution was thorough, and almost every element of it pointed directly back to her. The forensic completeness of the evidence against Hupp in the Gumpenberger case was almost without parallel in the case record for premeditated murder. The physical evidence, the sequential cache, the matched paper, the 911 call, the absence of any connection between Gumpenberger and Faria, formed an evidentiary triangle that left no credible alternative interpretation. Investigators who worked the case noted that the staging, for all its elaborateness, failed because each element of the plan traced directly back to Hupp. She had not used an intermediary for the cache. She had not prepared the note on untraceable paper. She had selected a victim whose disability made him manageable, but whose death generated an investigation that applied exactly the scrutiny she was trying to deflect. The Alford pleas. One for the Gumpenberger murder, one for Betsy Faria's murder, 6 years later, closed both cases without a trial, which meant that the full documented account of Hupp's conduct never played out before a jury. It is documented in the evidence nonetheless. The man she chose had spent years managing the consequences of a brain injury that had taken his independence and his livelihood. He had no connection to the case she was trying to influence. He was 33 years old. She chose him because he was the least able to stop her. Case number 5. Todd Kendhammer. On the morning of September 16, 2016, Todd Kendhammer called 911 from a rural road in La Crosse County, Wisconsin, with a frantic account of what had just happened to his wife. A metal pipe had flown from the flatbed of an oncoming truck, he said, pierced the windshield of the vehicle he and Barbara were traveling in, and struck her in the head. He needed help. She was critically injured. First responders reached the scene on a country road outside West Salem and found Barbara Kendhammer with severe head injuries. She was airlifted to a regional trauma center where she died. The pipe was there. The windshield was broken. The account had the shape of a terrible accident. Then investigators looked at which direction the glass had fractured. Todd Kendhammer was 46 years old and worked at a glass factory, an occupational detail that would not go unnoticed by prosecutors, given that the central evidence in the case involved the behavior of broken glass. He and Barbara had been married for 25 years. They lived in the rural communities of western Wisconsin and presented, by all available description, as a quiet, middle-aged couple with no remarkable history of conflict. Todd had no criminal record investigators identified. No plainly established motive was produced at trial. What the prosecution had in place of a motive was a physical reconstruction of the scene that pointed to something other than a pipe falling from a passing truck. Barbara Kendhammer was 46 years old. She and Todd had spent a quarter-century building a life together in La Crosse County. They were within a few years of retirement, approaching the stage of life that 25 years of work and marriage had earned them. She had 2 daughters who would attend their father's criminal trial. On the morning of September 16th, she was a passenger in a vehicle traveling along a country road with her husband of 25 years. She died that morning from blunt force injuries to her head. Todd's account was specific and internally consistent as a narrative. The metal pipe had separated from a truck traveling in the opposite direction, crossed the roadway, penetrated the windshield, and struck Barbara with fatal force. A pipe was found at the scene. The windshield was broken. But forensic examination of the glass fracture pattern, the analysis of how glass breaks, and which direction force was applied from, based on the geometry of concentric and radial fractures, indicated that the windshield had been broken by force applied from outside the vehicle, not by a projectile entering from an oncoming direction into a moving car. The breakage pattern said someone had struck the windshield from the exterior of a vehicle that was stationary or stopped. Barbara's injuries, distributed across her body, were inconsistent with a single pipe strike to the head through a windshield. She had scratches on her neck. Todd had scratches on his neck as well, the kind of marks produced by defensive contact with another person, not by the aftermath of a vehicular accident. Prosecutors concluded that Todd had beaten Barbara, retrieved a metal pipe from the vehicle's trunk, broken his own windshield from the outside to create the appearance of impact from the road, placed the pipe in the broken glass, and then called 911. Todd Kendhammer's trial took place in December 2017 in La Crosse County. The prosecution presented the glass fracture analysis, the injury distribution, and the physical inconsistencies between Todd's account and the forensic evidence as the foundation of its case. They also pointed to the 911 call, identifying what they characterized as delayed responses to the dispatcher, answers that lacked the immediacy of genuine emergency, and a register of panic that trained investigators found inconsistent with spontaneous crisis. The jury found Todd Kendhammer guilty of first-degree intentional homicide. He was sentenced to life in prison with the possibility of parole after 30 years, meaning his earliest release date is approximately 2047. He is currently in his mid-50s. The specific Wisconsin correctional facility where he is serving his sentence was not confirmed in public records available for this account. The story required a precise coincidence: a pipe falling from a truck at the exact moment a specific vehicle was passing, at the exact angle required to penetrate glass and strike a passenger fatally. The glass said the force that broke the windshield came from outside a vehicle that was not in motion. She was 46 years old, and she and Todd had been married for 25 years. The absence of a plainly articulated motive at trial was an unusual feature of the Kendhammer prosecution. In most domestic homicide cases, prosecutors present financial pressure, documented marital conflict, or an established relationship outside the marriage as a motivating factor. The Kendhammer prosecution did not produce a plainly established motive, in part because the investigation did not surface one in the available records. The prosecution instead relied almost entirely on the physical forensics, the glass, the injuries, the scratches, to make the argument that the pipe story was impossible and that the injuries were the result of a direct assault. The jury found that case sufficient for conviction. The sentencing to life with parole eligibility after 30 years, rather than life without parole, may reflect the absence of an established motive as well as the nature of the charge. First-degree intentional homicide rather than first-degree intentional homicide with aggravating circumstances. Barbara Kendhammer had been married to Todd for 25 years. She was 46 years old. The retirement she and Todd had been approaching was not far away. The glass fracture pattern told investigators that the story of the pipe was not possible. The jury agreed. Case number 6, Alex Murdaugh. Shortly after 10 o'clock on the night of June 7th, 2021, Richard Alexander Murdaugh called 911 from the kennel area of his family's Moselle estate in Colleton County, South Carolina. His wife Maggie and his son Paul had been shot, he told the dispatcher. He was describing their condition. At a point in the call, before the physical layout of the scene would have allowed him to have checked both victims. They were found at separate points across the kennel property, separated by significant distance. He told the dispatcher that neither one of them was breathing. That sentence would be returned to at length during his murder trial. Its implication was not that Alex Murdaugh had made an error of eagerness in a moment of shock. Its implication was that he already knew. Richard Alexander Murdaugh was 53 years old and the inheritor of a legal dynasty that had defined the power structure of South Carolina's Low Country for nearly a century. His grandfather and his father had served consecutively as solicitors for the 14th Judicial Circuit, and Alex had built his own career as a personal injury attorney with the institutional relationships and professional standing that the Murdaugh name provided. Beneath the surface of that standing, an entirely different reality had been accumulating for years. Investigators would eventually establish that Murdaugh had stolen more than $8 million from clients, including the family of a housekeeper named Gloria Satterfield, who had died in an accident on Murdaugh property, and whose son's wrongful death settlement had been taken by their own attorney. A financial reckoning was closing in by the summer of 2021. Simultaneously, his son Paul was facing criminal proceedings from a February 2019 boating accident on the Broad River, in which a young woman named Mallory Beach had drowned, and the growing scrutiny of the Murdaugh family in connection with that accident was adding pressure from another direction. Maggie Murdaugh was 52 years old. Paul Murdaugh was 22. They were at the Moselle estate on the evening of June 7th. Paul had his phone with him. At 8:44 p.m., Paul's phone recorded a short video at the kennels, a casual clip of dogs. Alex Murdaugh's voice is plainly audible in that video. Maggie Murdaugh's voice is audible as well. Alex had told investigators that he had been in the main house that evening, away from the kennels, when the murders occurred. The video, recovered by SLED, the South Carolina Law Enforcement Division, placed him at the kennels 22 minutes before his 911 call. The murders of Maggie and Paul Murdaugh occurred during that interval. SLED took primary control of the investigation from local law enforcement in the days following the killings. The phone video, which had been partially deleted, was recovered by forensic analysts. Alex Murdaugh was arrested on July 14th, 2022, more than a year after the murders, and charged with 2 counts of murder. His trial opened on January 23rd, 2023, in Walterboro, South Carolina, before Judge Clifton Newman. Prosecutor Creighton Waters built the state's case around the phone video and the 911 call, the video that destroyed the alibi, and the call that suggested the speaker already knew the outcome before he could have confirmed it. Alex Murdaugh chose to testify in his own defense. The jury deliberated for approximately 3 hours. On March 2nd, 2023, they returned a verdict of guilty on both counts of murder. Judge Clifton Newman sentenced Murdaugh the following day to 2 consecutive life sentences without the possibility of parole. From the bench, he told Murdaugh that it was hard to imagine a greater tragedy for a family than what Murdaugh had created. In separate proceedings, Alex Murdaugh subsequently pleaded guilty to more than 90 counts of financial fraud and related charges, adding federal and state prison time to sentences that already ensured he would not leave custody. Maggie Murdaugh was 52. Paul Murdaugh was 22. The video on Paul's phone placed his father at the scene. The sentence Alex spoke to the dispatcher. neither one of them is breathing, placed him in a different sense at the scene before he could have arrived there. The Murdaugh name had carried weight in Colleton County for 3 generations. The weight it carries now is of a different kind. The broader criminal investigation that ran alongside the murder case revealed a pattern of conduct that had been obscured by the Murdaugh family's institutional position for years. In addition to the $8 million stolen from legal clients, investigators documented insurance fraud, obstruction of justice, and a scheme in which Murdaugh had arranged, just 3 months after Maggie and Paul's deaths, to have a man shoot him in the head on a rural road, a plan designed to generate a $10 million life insurance payout for his surviving son. The gunman, a longtime Murdaugh associate named Curtis Eddie Smith, fired the shot at Murdaugh's request. Murdaugh survived. The attempted staged death was eventually disclosed and prosecuted. The financial crimes, the murder convictions, and the attempted insurance fraud together described a man who had spent decades using his family name, his legal position, and his community standing to insulate himself from accountability. Until the phone in Paul's pocket produced the evidence that his position could not absorb. Alex Murdaugh is currently serving his 2 consecutive life sentences. He has no parole eligibility. He is 57 years old. The 3-generation legal dynasty that the Murdaugh family built across nearly a century of low-country legal life ended at the Moselle Estate Kennels on the night of June 7th, 2021. The dynasty is over. Case number 7, Justin Barber. August 17th, 2002, was Justin and April Barber's wedding anniversary. They drove to the beach at Guana River State Park in St. Johns County, Florida, to spend the evening together. When Justin Barber reached 911 that night, he reported that they had been approached by an armed mugger on the darkened beach, that the man had demanded money and opened fire when confronted, shooting April in the face and shooting Justin 4 times in the chest before fleeing. Justin said he had driven them both, badly wounded himself, and April dying beside him, until they could find help and a signal to call. What investigators would find in the days following was not on the beach. It was on Justin Barber's home computer, and it existed before the anniversary. Justin Howard Barber was 30 years old. The marriage to April had reached a condition that would later be characterized as troubled, though the depth of that characterization emerged largely from the digital evidence recovered from his computer, rather than from any documented public conflict. In the weeks before August 17th, Barber had used his home computer to search specifically for information about chest trauma, survival rates in particular, for injuries to the right chest. On the night he reported being shot, he sustained 4 gunshot wounds. They were in his right chest. He survived. He had also, in that same pre-murder period, downloaded a song from a Guns N' Roses album. The song was titled, "Used to Love Her, But I Had to Kill Her." Both the search and the download predated April's death. April Barber was 27 years old. She had married Justin, and on their wedding anniversary, agreed to an evening at the beach, a walk along the ocean, a celebration of a year of marriage. She was shot in the face. She died from that wound. Justin's account to the 911 dispatcher and to investigators was internally consistent. An armed man had appeared from the darkness, demanded their possessions, shot April when they did not comply quickly enough, fired at Justin, and disappeared. Justin's 4 gunshot wounds, located in the right chest, survivable given prompt treatment, were treated at the hospital. He recovered. The physical reality of those wounds, taken alongside his pre-murder research into right chest trauma survival rates, formed the most concrete piece of premeditation evidence the prosecution would present. A man who studied how to survive being shot in the right chest, and who was then shot in the right chest and survived, had not been ambushed. The 911 call that Justin placed also drew investigative attention. Analysts and investigators noted the breathing pattern, heavy, rhythmic, and controlled in a way that differed from the irregular, reflexive breathing of someone in acute crisis, and the quality of the narrative he offered to the dispatcher. He provided context. He constructed an account. He offered the kind of explanatory detail that a person focusing their entire attention on a dying spouse is physiologically unlikely to produce. The call was presented at trial as behavioral evidence consistent with a rehearsed performance rather than a genuine emergency response. Justin Barber's trial took place in June 2006 in St. Johns County, Florida. Prosecutors placed the computer search history and the music download at the center of their case, presenting them as documented evidence of premeditation that predated the anniversary trip. The defense contested the interpretation, argued the searches were coincidental, the music download meaningless. But the jury was not persuaded by a reading of the evidence that required them to discard the most straightforward interpretation of what the computer contained. Justin Barber was convicted of first-degree murder. He was sentenced to life in prison without the possibility of parole and is currently serving that sentence in a Florida State Correctional Facility. He has been incarcerated for more than 2 decades. He is approximately 54 years old. She was 27 years old. She went to the beach on her anniversary. The mugger in the darkness, the chaos of a robbery at the wrong moment, the randomness of terrible chance. That was the story Justin Barber told the dispatcher. His search history had already told a different story, weeks before they drove to Guana River State Park. The Barber case was notable in 2006 for the central role that digital forensics played in the prosecution, a relatively early instance of computer search history, serving as primary evidence of premeditation rather than corroborating circumstantial evidence. The search queries were not ambiguous. The specific location of the chest wound, the survivability of that wound, the medical context for what would happen after being shot in the right chest. Taken alongside the music download, a song whose title described the precise crime that was committed, the digital evidence offered the jury something that physical evidence at the beach could not: documentation of intent that predated the event. The defense had no effective answer to the searches. The song download was contested as irrelevant. The argument that a person can download a song without endorsing its title is not unreasonable in the abstract, but in the specific context of a murder trial involving the killing of a wife, it was not a distinction the jury was prepared to draw. Justin Barber has been incarcerated for more than 2 decades. He is approximately 54 years old. He researched how to survive a chest wound before sustaining one. He downloaded a song about killing a wife before his wife was killed. She was 27 years old. She drove to the beach on their anniversary. The anniversary beach was planned. Case number 8, Michael Peterson. 2911 calls were made from 1810 Cedar Street in Durham, North Carolina, on the night of December 9th, 2001. The first call was Michael Peterson. He said his wife Kathleen had fallen down the stairs. She was still breathing, he reported. Then he hung up. A second call came minutes later from the same number. Kathleen was not breathing. The staircase in that house, a back spiral staircase off the kitchen of a large Tudor home on a wooded Durham property, became the most analyzed piece of domestic architecture in North Carolina criminal history. What happened on it, and what the blood on it and around it indicated, has driven 2 decades of court proceedings. It remains, in the technical legal sense, without final resolution. Michael Ivor Peterson was 58 years old at the time of Kathleen's death, a published novelist and a former candidate for mayor of Durham with a public profile in the city's literary and professional circles. Kathleen Peterson was 48 and a senior executive at Nortel Networks, the primary financial earner in their household. a woman of genuine professional accomplishment who had built her career alongside her marriage to Michael. After her death, investigators developed information about Michael Peterson that had not been publicly known. He had been corresponding through online channels with a male escort. Kathleen had not been aware of this. A substantial life insurance policy on Kathleen's life was also identified. The prosecution would argue that the combination of financial dependence and a secret that Kathleen might have discovered, and the catastrophic disruption a divorce would represent, gave Peterson reason to want her death to look like an accident. The physical evidence at 1810 Cedar Street was the prosecution's primary instrument. Kathleen Peterson was found at the bottom of the back staircase with 7 distinct lacerations to the back of her head, injuries that forensic examiners concluded were inconsistent with an accidental fall. The pattern of injuries, their number, and their distribution were more consistent with repeated blows than with contact against staircase edges. Blood was found extensively in the stairwell and on the adjacent walls. Michael Peterson's shorts and shoes carried blood in a spatter pattern that the state's forensic analyst, Dwayne Deaver, of the North Carolina State Bureau of Investigation, testified placed Peterson beside Kathleen while she was actively bleeding, not as someone who arrived to discover her after the fact. The prosecution also introduced the case of Elizabeth Ratliff, a woman who had died at the bottom of a staircase in Germany years earlier, while Michael Peterson was stationed there. Her remains were exhumed, and her manner of death was reclassified as homicide. 2 women, 2 staircases, 1 person present in both cases. Peterson was charged with first-degree murder in 2003. His defense attorney, David Rudolph, challenged the blood spatter analysis and presented Kathleen's fall as a genuine accident, pointing to her blood alcohol level, the darkness of the staircase, and the mechanical complexity of the spiral structure as contributing factors. Rudolph's cross-examination of Deaver was aggressive and substantive, challenging the methodology underlying the testimony. Peterson did not testify. A Durham County jury found him guilty of first-degree murder, and he was sentenced to life in prison without the possibility of parole. The trial was simultaneously being filmed for a documentary series that would eventually become one of the most watched true crime productions in television history. In 2011, an independent review of the North Carolina State Bureau of Investigation established that Dwayne Deaver had committed perjury in the Peterson case and had fabricated testing results in multiple criminal prosecutions across the state. Peterson's conviction was vacated. A retrial was ordered. In 2017, facing that retrial, Michael Peterson entered an Alford plea to the charge of voluntary manslaughter, acknowledging that a jury could find sufficient evidence to convict him of that offense, while formally maintaining his innocence of murder. He was released from custody with credit for the 16 years he had already served. He returned to Durham, where he lives today at the age of 80. The expert whose testimony convicted him fabricated his results. The conviction was overturned. The Alford plea that followed is neither a conviction for murder nor an exoneration of responsibility. Kathleen Peterson was 48 years old. She was the financial foundation of the household she and Michael shared. The staircase on Cedar Street holds the answer that the courts have not, across more than 2 decades of proceedings, managed to deliver. The Peterson case had a dimension that the legal proceedings only partially addressed: the question of Elizabeth Ratliff. Ratliff had been a friend of Michael Peterson's when he was stationed in Germany, and she died at the bottom of a staircase in Bad Vilbel in 1985. Her death was ruled a stroke at the time. In 2003, following Peterson's indictment, her remains were exhumed and re-examined. The manner of her death was reclassified as homicide. 2 women in 2 countries, in 2 decades, had died at the bottoms of staircases while Michael Peterson was present in their lives. That pattern was admitted at trial over defense objection. David Rudolph challenged the relevance and the reliability of the reclassification, arguing that the Ratliff evidence was being used to imply a pattern of behavior that had not been established. The jury heard it. What weight they gave it in their deliberations is unknown. Rudolph's challenge to the Ratliff evidence remains one of the more substantive legal questions the case produced. Michael Peterson is 80 years old and lives in Durham. He is free under the terms of the Alford plea he entered in 2017. The conviction for first-degree murder no longer stands. The charge of voluntary manslaughter does. Whether what happened at the bottom of the staircase on December 9th, 2001 was a murder or an accident has not been definitively resolved by any court whose decision has survived.